Welcome to a new episode of the podcast Immigration Law. I am attorney Fabio Loscerbo. Today we examine a significant decision issued by the Regional Administrative Tribunal for Puglia, 3rd Section, concerning case number ruolo generale 347 of 2026, decided with judgment number 386 of 2026. The case concerns the revocation of a clearance for the conversion of a residence permit from seasonal work to subordinate employment. The Prefecture had considered the housing documentation unreliable, pointing to discrepancies between the signatures on different copies of the rental contract. This is where the core of the decision lies. The tribunal notes that, in practice, it is entirely normal for multiple copies of a rental agreement to exist, each signed separately, one for the landlord, one for the tenant, and often an additional copy for a consultant or for tax registration purposes. Expecting perfect identity between signatures on all copies reflects a misunderstanding of real contractual practices. As a result, the court finds that the administrative decision is affected by several legal defects: lack of proper investigation, insufficient reasoning, and misinterpretation of the facts. The outcome is clear: the revocation is annulled. However, there is an important clarification. The tribunal states that the administration retains the power to reassess the case and verify whether all legal requirements for the permit conversion are actually met. This decision confirms a fundamental principle. Administrative authorities cannot rely on rigid formalism detached from real-life circumstances, especially when fundamental rights such as the right to stay and work are at stake. In other words, administrative procedures in immigration matters must be properly conducted, thoroughly investigated, and grounded in reality. When this does not happen, judicial review becomes essential. Thank you for listening. See you in the next episode.